Hi, Bill Henshall here again, and I'm introducing you tonight to my new YouTube channel called You Win in Court. And the email for that will be youwinincourt@gmail.com. And this channel I'm going to introduce in order to give you a simplified program to know how to go about dealing with court personnel, getting your case into court, and beating the badgers and keeping it comparatively simple. For the most part, thankfully, it is. But on the occasion you run into difficulties, that's what I'm going to teach you how to deal with. And we're getting more and more of that recently in California, a subject for another video. But trust me, this is a tell, because if they don't want us filing documents and they don't want our issues in there, what does that tell you? They can't answer them. You win. That's the whole point of this video channel, is to do that. So tonight I'm going to start with some introductory documents and introducing you to a lot of documents in my constitutional defense documents that you can get at a very modest price. We'll mention that later. And you go in and file these things, and you take control of the case from the beginning. You take it away from them, and you never let them have it back. That's the kind of power we have once you understand at least a little about constitutional law and do some studying. It's going to take a little time and effort on your part. These aren't magical documents. They may just seem that way at times, but the more you study, the more magical they get. So, that said, I'm going to open up with the Bill of Particulars, and with you understand what this document is and what it does. And just like me, they didn't teach me 50 years ago either a damn thing about this. I didn't know. I had to learn the hard way. I figured it out. I'm going to save you a lot of time and trouble doing the same thing here, because this document, the Bill of Particulars, is the foundation document for all that follows, since we have the right to know the nature and cause of the accusations, aka jurisdiction and venue of the quote-unquote court, the rules of the game, definitions of all elements of the crimes charged, and the identity of the injured party, and even more info than this, in order we can attempt to put on any defense at all, let alone a meaningful and substantive defense which we have the right to do. And think about it. If we have no way to put a defense on, why bother with the trial? Just issue the damn directed verdict of guilt already, which most of you know is the inevitable result in at least traffic court trials. Those of you that have followed my videos know that according to the 9 farts, aka the U.S. Supreme Court, the Bill of Rights does not apply to the states. Barron v. Baltimore, 32 U.S. 243, 190-year-old case, still there, not reversed. So what the hell am I doing here with the Sixth Amendment? The answer is that we are not in a state, but a federal insular territorial possession. A video upcoming on another occasion, I'll explain it to you. Thus, the Bill of Particulars is not only readily available, it is much more important in a federal insular territorial tribunal, as set forth in detail in many of the documents in my modestly priced constitutional defense documents. More information on these readily available at youwinincourt@gmail.com. So what is the local dumbass and or black robe bastard, BRB, hiding that they don't want you to know, and the entirety of the justice system wants to keep carefully concealed? I say dumbass here because the local prosecutors are either so poorly trained in law school that they do not understand the issues, and or even worse, they actively aid and abet those whose goal is to overthrow the Constitution and lawful government of the United States. The same can be said for the BRB's brethren of their state bar association attorneys, who have at least this irreconcilable conflict of interest, but who also seem to have a high priority of maintaining the malevolent monopoly on the practice of law of their partners in crime. If you know of anyone belonging to a state bar association who acts otherwise, I'd love to hear about it. Please remember here that all the information in the demand for a Bill of Particulars must be provided, a lot of which will establish the absence of jurisdiction of a trial court, quote-unquote, and place the perps, aka quote-unquote official actors, in a situation where their deceit, fraud, and even treason to the Constitution will come back to bite them in the ass in front of an inflamed jury. And a BOP is not discovery, quote unquote, which they think it is, since this is a general appearance and thus a stipulation to the jurisdiction of the trial court, which it could get in no other way. The title page of the BOP makes this crystal clear, except for doppelgangers of Matthew Peterson. The really exciting part here is that in 4 decades I have never known a BOP to be even acknowledged, let alone answered, by a local dumbass, yet they had the constitutionally mandated duty, not to mention sworn oath of office, to be bound by this Constitution and laws enacted in pursuance thereof, to promptly provide all the information demanded in the BOP. Please let me know immediately if you ever get such a response. Often the filing of the BOP alone, let alone in concert with my other documents, is sufficient to put the bastards on notice they are dealing with someone who has taken the time and effort, albeit never having been taught a damn thing in the mandatory public quote-unquote education system about the Constitution, history, and laws of the United States, to learn how to invoke their rights and that the battle is on. Do not be surprised if the charges get quietly dismissed, quote-unquote, in the interest of justice when the cop does not show up at a quote-unquote trial. Have you ever heard of a cop being charged with a willful failure to appear in a traffic court? It gets better. With an unopposed record in the traffic court, you are now in a good position to use my developmental protocols for an offensive action for petition for redress of grievance. With such efforts already afoot, and the only relevant admissible record before a jury will be the record in the trial court. With my help, you are a favor to beat their motion to dismiss, which all but ends the matter in your favor. Check it out in other videos, and for more information about the availability of my constitutional defense documents at youwinincourt@gmail.com. And to the listeners, don't forget to like and make comments about my channel, especially the other people. Turn them onto it. Let them know what's going on here. Thank you.